All right. Good afternoon, everyone. Welcome. This is the first series, or the first course in our Other State Mandatories webinar series. This is going to be the Professional Engineering Ethics presented by Kevin Cito and Dave Ranich. I just have a few housekeeping announcements before we get started. The first being just a general reminder that if you take this course, that's going to satisfy the Indiana ethics requirement. And if you take this course and next week's ethics course, that will satisfy the Wisconsin requirement. And also a general reminder that these webinars can also qualify as a PDH for Illinois. We do have the handouts in the quiz available. The handouts are also near the bottom of your screen underneath the questions tab, and they're also available on our website along with the quiz. You should have received that link in an email. If you didn't, you can go ahead and email info@illinoisengineer, and we'll get that sent to you. Please complete the quiz by Tuesday. That way we can get your PDH certificates to you as soon as possible. If you guys have any questions throughout the presentation, you can type them in the question box, and I'll go ahead and read those aloud to our presenters at the end of the session. All right, so that's all. Thanks for listening. I'm going to let Kevin and Dave take it from here.
All right, thanks very much, Ariana. Kevin Cito here, and along with my partner, Dave Ranich, we'll be speaking today. Our bios are at the end of this PowerPoint, and we'll let you look at those later, but suffice to say, between Dave and me, I think we have probably over 85 years of experience in dealing with engineers. That's a staggering sum, Dave.
Don't remind me.
But at any rate, I practice in the Chicago office of Hinshaw & Culbertson, and I've represented engineers and architects and other design professionals for a long time, and certainly in the realm of ethics with some frequency, at least as the need will arise. Dave, how about your experience?
Well, I too practice with Hinshaw in our Cherville, Indiana office. I do have 40-plus years of experience dealing with corporations and other business entities in any number of transactional and real estate litigation and corporate governance matters. I have served as general counsel for a 200-plus member professional engineering and consulting firm for probably the last 15 years plus. And since 2012, when Indiana required mandatory continuing education, I have trained Indiana PEs at Purdue University in Hammond.
Well, we're lucky to have Dave because he's done a lot of these presentations, and I've done a fair number as well for Illinois and Wisconsin PEs and structural engineers as included. So let's move on from there then. So our learning objectives today. We, of course, want you to get a better refresher, if you will, because I'm sure many of you have listened to us in the past, perhaps 2 years ago. And we're going to be focusing on Indiana and Wisconsin. We'll have some passing comments on Illinois as well. One of the things, though, we want you to do is to acquire a sense of purpose. And a bullet point that's not there but could be there is we want you to learn what to do if an issue arises. Where do you look for help? How do you get help? What do you do? That's an important feature here because you just never know when one of these is going to arise, as we'll be talking.
The next slide, I think, gives us the source of the Indiana ethics laws. There is a website available, a state website, and the Professional Engineering Practice Act is also found. The site there is on the page as well. Also need to be learned about the procedures, practice and procedures that are not in the statute, but they are also part of Indiana law. And we'll talk about those today.
For Illinois, because as we know, structural engineers are licensed separately than professional engineers, there's a set of parallel rules. I've gone through and I have found after many pages and pages of the statement of these rules, there's only about 4 or 5 words that are different between PEs and SEs in Illinois, but nonetheless, you see there the particular rules about the standards of professional conduct. When we get to Wisconsin, they have chapters AE 2, 8, and 13. 13 speaks about the professional education requirements on a continuing basis. Article 2 speaks about general requirements for architects, PEs, professional land surveyors, and designers, including landscape architects. And they talk about various things about registration seals, branch offices, how there must be a resident PE in each separate business location, so forth and so on. Chapter 8 has the rather typical and traditional, if you will, statement of ethical practices. Now, today we're going to tend to focus, like I say, about Indiana and go through the listing of the Indiana particular rules, but I can tell you, if one were to compare Wisconsin, Illinois, and Indiana, there's no set of rules that are drastically different. There's just a few things here and there, which I'm going to try and point out along the way. So let's start in with Indiana then, Dave. Well,
the grounds for disciplinary action are found at the citation shown on the screen, 25.111.5. And the practitioner has to comply with the standards established by the Professional Engineering Board, and they're subject to the exercise of disciplinary sanctions. Now, there are a number of grounds that are found at this statute that I think bear mention. Certainly, you can be disciplined if you have engaged in or knowingly cooperated in a fraud or material deception in order to obtain your license, including cheating on a licensing exam, engaging in fraud or material deception in the course of professional services or activities, or advertise services or goods in a false and misleading manner. Another ground that I think there's a lot of case law on is the second ground, and that is you've been convicted of a crime that has as they say, a direct bearing on your ability to continue to practice competently. The Indiana Professional Engineering Board has given that a very wide reading, if you will, and not a narrow one. There are a total of 9 grounds, but those 2 are probably the most important. Certainly, practicing without a current license will get you disciplined, but it's unlikely you'll lose your license in that regard. Kevin, you've got the next slide up showing Title 864 of the Indiana Administrative Code. Rule 11 deals with the ethical concerns. There are 25 separate sections within Rule 11. 6 deal with enforcement. 2 deal with ethical obligations, primary ethical obligations. Everything seems to flow from those 2. 6 deal with technical competence requirements, and no less than 11 deal with conflicts of interest as an elaboration of the duty through objectivity and truthfulness. Kevin,
well,
you can, I think.
Yeah, go ahead, Dave.
I was going to say, I think you can move on to the next screen.
Well, one thing too about ethics is obviously common sense always is a touchstone here. Your conscience about what seems to make sense, and I still go by that rule that if you think you're too close to the line, well, you probably are. One thing you need to watch out for, though, too, when it comes to ethics is some of our state rules have some particular nuances that might not seem so obvious. Anybody knows, for example, you can't expect to practice ethically if you're issuing bribes. I mean, who needs a rule to tell you that? But on the other hand, though, there's some other rules that we're going to try to cover here, and I will urge you to read the rules, where you might find a few things that jump out at you as something that was not so obvious but nonetheless is just as much the force of law as these obvious ones that we'll be talking about as well. So, one thing too is, of course, the respective boards can take disciplinary actions for matters beyond what some might call ethical violations, as we give the example, failure to file tax returns, failure to file child support. But we're going to be talking about the more traditional ethics ideas here today. And one thing too, again, from a procedural viewpoint, is you certainly want to remember that ethical questions can turn on specific facts. And if you're looking for advice or giving advice, like everything, make sure you get all the facts as opposed to jumping quickly without enough information. So let's talk with
Kevin,
Indiana Rule 11, Dave.
Sure. Kevin, can I just go back for a minute? And, you've given some examples on a previous slide about other grounds, perhaps not related to engineering per se, that can get you in hot water with the board, such as tax returns. We have a fairly recent case in Indiana in 2014, the Ernst case, where the engineer pled guilty to a federal charge of extortionate extensions of credit. Now, I'm not quite sure what that statute reads, but he pled guilty to it. Didn't have anything to do with engineering, but in the federal court, he pled guilty and received probation, had a substantial fine, but when it came before the Indiana Professional Engineering Board on an administrative complaint, they revoked his license. So it seems, what does that have to do with engineering? Well, the Professional Engineering Board thought otherwise. So, Kevin, I'll go back to the slide that you've got. Indiana Rule 11 does cover the ethics and professional practice. Let's start on Section 2. These rules apply to you as soon as you become a PE. You have to read them and abide by them. And you have to remember that the practice of engineering is a privilege, not a right. And in that regard, you've got to be forthright and candid in communicating with the board. And I think I referenced that in the statute that I talked about a minute ago in terms of the fraud in doing anything to do with your license. Section 4 is probably the most important ethical consideration found in the Indiana rules. If the professional engineer's professional judgment is overruled and public safety, health, and welfare is endangered, the professional engineer must inform his employer of possible consequences and the proper authority as appropriate. The key is the primary obligation is to the public and their welfare.
And I will quickly jump in and say that similar wording exists in Wisconsin and Illinois. I mean, Dave and I were talking about this, and we just cannot overstate the importance. Which brings up then a point, everybody was following, I'm sure, although it's tending to be older news now, but the collapse of the walkway in Florida. And Dave and I looked at an article in the New York Times where it said that the engineer had called the Florida governmental agency the weekend before the collapse and reported that there might have been a question or a problem that needed to be looked into. And Dave and I have talked about that, and we go back and forth in the sense, did that engineer do what he or she should have done? And just using that as sort of a hypothetical as opposed to literally judging that person without knowing all of our own facts. But the question arises, though, just what should an engineer do if he or she sees something that causes a question? Is making that phone call enough? Now, we have no reason to believe that the PE's professional judgment had been, quote unquote, overruled. Yet, notwithstanding that, is it enough? Dave, what do you think?
Well, I'm not sure that it was enough. The particular facts in that case, the fellow who made the call was the lead engineer with the company in charge of the bridge's design. And he left it in a voicemail to a Florida DOT employee. And it wasn't listened until the day after the collapse. Should he have done more? What he reported was, and I'm going to quote what the voicemail said, we've taken a look at it, and obviously some repairs or whatever will have to be done, but from a safety perspective, we don't see that there's any issue there, so we're not concerned about it from that perspective. Although obviously the cracking is not good, and something's going to have to be, done to repair that, end quote. Kevin, I don't know if that was quite enough, because, like I said, 2 days later, after he left the message, the bridge did collapse. We don't know enough right now. I think I would have done something more other than just leave a voicemail. I might well have sent some type of writing to memorialize it as well.
An email.
Yes.
And now, when you read that, though, the engineer is saying that he doesn't think it's a problem. And so we've arguably got a situation where not only was his judgment not overruled, but he was thinking that public safety was not endangered. Nonetheless, he was raising the question. Now, and for purposes today, we want to separate out civil liability or negligence liability on the one hand from ethics on the other, because today's subject is ethics, not whether or not he can be sued. That's another story, another subject.
Definitely. Kevin, let me just say, just from that quote, it would seem to me that was he relating something factual, or was he relating something of an opinion?
Well, that's a good question.
That, I think, he may have some ethical concerns simply by expressing an opinion without any factual backup. And I think we'll talk about that in a bit.
Well, stop right there just for a second. If he thinks he sees smoke, should he have then investigated to see if there was fire?
That's right. Yeah.
Well, all of these present very interesting questions here that that certainly will come under huge scrutiny, I'm sure, in the years to come. And that engineer, wow, I mean, I'm sure there are many, many things he wishes he had done with hindsight.
Well,
so when we look, yeah, go ahead.
Kevin, just to finish on this Florida case, the National Transportation Safety Board was quoted as saying, what role, if any, the cracks played in the collapse has yet to be determined. So stay tuned, I guess is what I'm saying.
Well, that's right. And when we look at these words, and if we start to parse them a little bit, what does endangered mean? A little bit of danger, loss of life, well, that's obvious, but a danger to the structure or danger to life? And who is the PE's employer? In other words, right. If you're employed perhaps in a firm of 5, 6, 8 people, much less 50 or 80, can you talk to the boss, talk to the owner of the company, or are you talking about your client? I would suggest to you that the definitions here are a little fluid, a little elastic, and if you didn't give the notice, be ready to face the definition that it's as broad as you can imagine when seen after the fact. Now, we raised in this last bullet, what if the engineer of record holds a contrary opinion? What do you think then, Dave?
I think if you're the subordinate engineer who feels that there's a matter of danger, you have an obligation to go directly to the client and tell them that. I think if it's serious enough, you do have an obligation.
Well, and we point out here that you can expect that it will be judged by an objective standard. So even if you don't think subjectively that it's much of a problem, but they line up experts after the fact who say, oh, yes, that was a problem. That crack was in a critical place, blah, blah, blah. You can expect to be roundly criticized, and hindsight is always going to be an issue. There's just no getting around that.
Right. Right. There is a, before I leave that, Kevin, there's a pretty good number of cases, a couple cases that have to do with a trench collapsing, one in New Jersey, one in Indiana. The Indiana court exonerated the professional engineer in that regard, said there wasn't a duty. The New Jersey Supreme Court said otherwise. They said they went out and said they had a duty. And mind you, the engineer in the New Jersey case did not have, wasn't the engineer that had designed anything. He was only there to make sure that the contractor was following what it was supposed to do. He had no authority over the design. And yet the New Jersey Supreme Court found him liable.
Well, just one quick idea on that. If you were going out there as a professional engineer and was being asked to verify that that the bricks were of the correct specification, or that the concrete was good, and then out of the corner of your eye you see a trenching operation going on, and it's obviously poorly done in the sense that it's not sloped appropriately, or there's no sandbox or anything. These cases that Dave is referring to could easily come into play, because they'd say you can't just, can you put blinders on, I guess is the question.
Not in New Jersey.
Well, it's a difficult situation.
And I dare say that in Indiana, you might have the same result in New Jersey, but in Indiana, the appellate court sent it back to the trial court because of a faulty jury instruction. And we don't know how it eventually ended up.
Probably settled.
Probably did settle. At the trial court level, the engineer was found liable, and they appealed. And the Court of Appeals agreed with the engineer and said, you got a faulty instruction to the jury, and so they sent back. And I agree with you, Kevin, it probably did settle.
All right, well, let's move on from there now. Dave, tell us about rules or sections 5, 6, and 7.
These deal with the concept that you've got to practice only in the area that you're competent, that you can only sign and seal drawings in an area in which you're competent, and can only accept assignments within your area of competence, but can supervise others who have the proper qualifications. I will say that in Section 7, having to do with the signing and sealing of plans, is probably one of the two most disciplined areas in Indiana.
Well, and we get into plan stamping as well. I think that's a practice that's not nearly as prevalent as it was, say, 40 years ago. But I think any PE that does plan stamping, by that I mean stamping plans that they had no involvement in, but they'll do it for $50. Wow, they're going to get hammered by the regulators. And I'll say quickly here, you'll notice in Section 7 that reference to the nature of pre-designed manufactured equipment. That's something that only exists in Indiana. That is a feature that doesn't have any recognition in Illinois, Wisconsin, or for that matter, Minnesota, when I looked at their rules a while back as well. It's just a neat feature that Indiana recognizes and frankly recognizes as a matter of good common sense. Well, let's move on to a question here. So here's something that could happen in a firm that is practicing in in both Indiana and Illinois. So here's our question. Joe is Indiana registered PE, the only one in an Illinois-based firm. There are many experienced Illinois licensed PEs or SEs in his office, and they produce a design in a field of engineering outside of Joe's own competence. Maybe Joe is a mechanical engineer, and that Illinois SE, who's not licensed in Indiana, comes to him and says, Joe, I need you to seal these design drawings. Joe is saying to himself, but I don't practice in the field of structural engineering, even though I'm registered as a PE in Indiana. Can he seal the drawings? Dave, what would you say?
Well, I think Section 7 is pretty clear on that point, that he cannot sign and seal those drawings.
So what's the solution then? They find an Indiana registered PE who is competent in structural engineering, and or the employee who's the Illinois SE quickly runs and gets registered as a PE in Indiana, I suppose, right?
Correct. Yeah, they're going to have to get someone who has got the proper credentials in Indiana.
And I think this is one, now again, Dave, your knowledge about what regulators have done in Indiana is quite vast, but have people been called in on the carpet on this competency business or sealing drawings that are really not in their bailiwick?
There are,
but maybe not that frequently.
Not that frequent, and I have to say, just with a broad stroke, Kevin, that administrative complaints and disciplinary complaints in Indiana are somewhat sparse over the years. I would say that in the last 20 years, there probably are maybe 30 reported decisions. That's not very many over that period of time.
I agree. And in Illinois, I will tell you that they're even scarcer. It's kind of hard to find them, to know what people are doing. My experience in Illinois representing engineers and architects that have been called in is that they tend to get resolved relatively early. I would say that most professionals realize the wisdom of resolving it early and not making a quote-unquote federal case out of it. And the last thing they need is for their name to be associated in something that's published to the community as a whole.
Right, and be mindful too, Kevin, that how does the Professional Engineering Board operate? Well, they only operate based on information that's brought to them. Okay, i.e., a complaint or shall I say a whistleblower in some regard?
Yeah.
So it's just not something that happens very frequently.
All right, let's move on to Section 9.
Section 9, of course, deals with complete objectivity and truthfulness in all professional reports, statements, or testimony. That's kind of a key word. The engineer has to include all relevant and pertinent information in those reports, statements, or testimony. So I go back to what we just talked about with Florida. That, if you want to call it a report in that voicemail, did not include all relevant and pertinent information. Frankly, I don't think it was anything more than an opinion. So in that regard, that engineer, judged under Indiana standards, probably has an ethical violation there.
Yeah, I would take the other side of this in the sense of saying that, in fairness to him, a brief telephone message is not a report in a classic sense. Is it a statement? I don't know. I think in fairness, he'd be given a chance to develop it. But again, though, it's a matter of speaking up and not hiding the information, which kind of brings me to this next idea. When somebody is sworn in as a witness, they might be asked, do you solemnly swear to tell the truth? And then our point would be the whole truth and nothing but the truth. So what do you do when a lawyer wants only his side of the truth? The engineer needs to be honest, but of course, the engineer needs to appreciate that the lawyer is an advocate. The engineer called upon as an expert is not an advocate. So that brings us to Section 10.
And of course, you know, when we're talking about testifying, an engineer, whatever he's going to say, it has to be founded upon adequate knowledge of the facts in issue, upon a background of technical competence in that subject matter, and upon the honest conviction of the accuracy and propriety of his testimony. So that's a lot of weight there in terms of what you have to make sure you do when you're providing testimony, and you have to stick to your guns in that regard.
Well, that's right. That's right. One of the things I would quickly point out in Illinois, there's a slightly different twist on this. It would say everything that we read here about Section 10, but they'd also go on to say that if a professional engineer or structural engineer is called upon to offer a public opinion, such as being interviewed at the site of a collapse by a newspaper or television reporter, they would have the same thing. While it's not testifying as such, they would say PEs and SEs in our state of Illinois should express an opinion only when they've, first of all, of course, have technical competence, but also have an adequate knowledge of the facts. You can't just pull up, look at the collapse and say, oh, I'm sure it was the blank, blank, blank. I mean, wow, that maybe it's that obvious, but I dare say it probably and usually is not before you'd want to be saying those things. So what about the client's lawyer? You know, you want to be concerned if the lawyer starts giving you tips on what to include or not. But again, you know, let me stress from the lawyer's point of view, the lawyer knows what issues are in the case. The engineer probably does not. Right. The lawyer knows what they want to offer to the court, including the jury. And so you want to stick to your guns with your own ethical obligations, but yet listen and, you know, work carefully with that lawyer. One other thing, too, by the way, that comes up maybe once in a blue moon is it ever possible for an expert to testify or consult on a case and be paid on a contingent fee as opposed to a straight lump sum or hourly? Dave, what would you say to that?
Well, I'm not very comfortable with that. I think
I would be never comfortable.
Yeah.
Never.
Right. To peg an outcome that would shade your testimony is, I think, inherently unethical.
I've urged experts to demand full payment before they testify, which is nice for the expert, lest the opposing lawyer cross-examine them and say, well, you're only going to get paid if your side wins. Interesting point. Now, right. You know, the battle of experts, you know, it's, as we saw on the earlier slide, an honest conviction. And certainly, you know, somebody's going to win and somebody's going to lose in virtually every trial. And of course, that doesn't mean that if you're an expert and your side doesn't win, that you've somehow committed an ethical wrong. You're there as an expert to inform the jury about things the jury doesn't know about. And you should not be open to liability for damages if you've done your job, done your homework, not made a mistake, for example, in your calculations, of course, right. But you should have no liability to your own client or to the other side. And there are many cases that have addressed that issue.
You know, and in that regard, Kevin, I mean, if you've got an adequate factual background to support your calculations and your resulting testimony, there shouldn't be any ethical concerns at all or any liability concerns at all. All
right, let's move on to public speaking then, public speech.
Well, Section 11 does speak to that, and you know, an engineer is prohibited from making any statement or arguments connected with public policy, which, as the rule says, are inspired or paid for by an interested party, unless the engineer has prefaced any comment he makes or she makes by explicitly identifying him or herself, disclosing the identities of the party or parties on whose behalf he or she is speaking, and you've got to reveal the existence of any pecuniary interest of the professional engineer. I mean, that's straight out of the rule.
All right, so let's use this example then.
Ajax Windmill wants to hire Sue Sine, a professional engineer, to have her be interviewed by the press on why windmills should be allowed on Lake Michigan. She believes that's a good idea, personally. What would Sue's statement to the press look like? Well, I think, again, looking at Section 11, she has to identify herself, disclose the parties on whose behalf she appears, and state what kind of remuneration she's receiving.
Do you think she needs to say how much, or just that she's being paid?
Oh, I think it's sufficient that she's simply being paid.
I agree. I don't think it needs to get into whether it's $500 or $5,000 or whatever. I think the public gets the message that
right.
She's not just any person that just happened to be walking along the sidewalk and they thrust a microphone in front of her.
Right.
Well, let's talk about conflicts of interest, because these are always a concern. Now, one thing that's a little intriguing here to Dave and I as lawyers, it says that, of course, avoid them, but when unavoidable, disclose the circumstances. And they don't say at that point to withdraw. Now, lawyers face these conflict issues, and in general, lawyers, if they do have a conflict of interest, have to withdraw. They can't be involved. Merely disclosing the circumstances and yet rolling forward probably doesn't work for lawyers. Now, I mention this just because a lot of times lawyers are involved in ethical questions, even for engineers, architects, landscape architects, the whole thing. And my experience has been in talking with other lawyers, sometimes they perhaps unconsciously, but nonetheless want to impose lawyer rules on engineers or other professions. That's wrong. But that's where you as an engineer want to hold your guns or stick to your guns, and just because the lawyer says so may or may not make it true. Now, here again, on further comment about ethics, here they're saying you have to disclose and inform your client of any circumstances that could influence your judgment or the quality of the services. It could possibly, depending on the circumstance, be even a prior association. You used to work for a manufacturer, now you are on your own, and yet you want to specify that product. Could that influence your judgment? Oh, you got to have knowledge from some source, and if you're not getting any quid pro quo, I mean, I think you can continue to specify, you know, Ajax or whatever brand name it was. But again, this is one of these things that can easily be judged in hindsight when a competitor, for example, the company whose product wasn't specified might jump in. Again, you want to say to yourself, is there an appearance of impropriety? That's something that we as lawyers are judged by, but again, it's the sort of thing that you can find yourself being tested on, so to speak. Does it smell bad? Are the optics bad, to use current terminology? And if you're making the informing of a client or your employer, as the case may be, we certainly urge that it be documented by email. And if you're seeking a consent, by sure means document the receipt of that consent as well. It's so, so important. Dave, what would you say in comment to that?
Well, you know, what you said earlier, Kevin, is that if you're too close to the line, you're probably over it. And this is a perfect example of that, if you think you've got a problem, just disclose it, get it out there, and make sure everyone knows. And let's see what the ramifications of it are from that point forward.
All right, let's move on from there. Undivided loyalty.
Well, of course, Section 14 is clear. You can't accept compensation, financial or otherwise, for more than one party for the services on the same project, unless the circumstances are fully disclosed to and agreed to by all interested parties. Again, the purpose behind it is you want undivided loyalty on the part of the engineer. Again, you need to document the disclosure and the agreement. Kevin, let me throw out an example. Let me ask what you think about it. You've got an engineer who is, say, the fully retained professional engineer for a municipality. The municipality decides to undertake some public work, and the engineer's firm decides to bid on that work, and is awarded the contract to perform those services. Does the engineer have a problem, do you think?
Yeah, I think so, because I think there's, I think it would look as if the reason that they got that contract, which we would presume, by the way, under a qualification-based selection process, would have been done on merit as opposed to the low bid. I think that it just doesn't look right, that they were somehow on an inside track.
Right. I tend to agree with you on that.
On the other hand, though, it could be that the contract of employment, when that engineer was hired in the first place, may have spelled that out, and the contract may very well be a public record, and it gets into the difficulty, if you will, between expediency and efficiency in saving public money on the one hand, with what some might think of as a sweetheart deal on the other.
Right.
Difficult
it's fraught
situation.
It's fraught with issues. There's no question about it. Section 15 talks about not soliciting or collecting any type of gratuities. Again, seems to me this is kind of common sense, that are coming from any contractors or other parties dealing with the engineer's client or employer. Is that to say that the engineer can't accept anything under any circumstances? I would suggest that there might be an informal bright line, and it would be a dollar amount above which would be prohibited, below which would not. I mean, let's face it, the IRS has taken kind of a bright line test in that regard.
But Dave, what does it say here, though? It doesn't put in a threshold.
Oh, I agree with you, Kevin. But I do think that this bright line number is not a big number. I'm saying $25, perhaps, not much more than that.
You wish it were, in other words.
Yeah, right.
Okay, well, 16 is similar also. You can't solicit or accept value from suppliers for specifying their product. Gee, I mean, that shouldn't be any surprise to anybody. But on the other hand, though, what if the timing is different? In other words, if the PE calls up the distributor and says, if you give me X, I'll specify your product. Oh my gosh, that's terrible. But what about if it's the other way around? The engineer specifies what she thinks is the best product, and then the distributor, shall we say, recognizes, for lack of a better verb, that decision to specify its products and sends something of value, I think that's where the phrase accept value comes in. You got to send it back according to this, and that's just all there is to it.
Right. Right.
Let's yeah, go ahead.
Again, how does the Professional Engineering Board find out about something like that? Pretty hard.
Well, that's right. I think the worry, though, is somehow, some way, things turn south, turn sour, turn whatever, and the worry I would have as a professional engineer, just like lawyers have, is that the member of the public claims to be an idiot and says, oh, I didn't know that, and then the regulators want to chase after the person with the license that they might believe is a more valuable fish to catch. We certainly see that with federal prosecutions. You know, the small fry turn government witnesses, and then they go after the big person.
Right.
Classic situation.
Right.
Let's move on then to these next 5, Dave.
Yeah. Section 17 talks about public bodies. You can't participate in decisions on jobs where you are the P or C contracts. 18 talks about soliciting or accepting an engineering contract from a governmental body on which the principal officer or employee of the organization serves as a member. 19, payment of consideration to secure work, which is prohibited. I have to say I want to stop and talk about 19. I have heard more ethical concerns raised by professional engineers on the issue of making political contributions in order to secure work than virtually any other section we've talked about today. It is a way of doing business, unfortunately, in some places, Kevin.
Well, there's no doubt.
It's ethically, it's a very much of a quagmire. And, you know, what's a professional engineering firm going to do when they've got, let's say, $100,000 engineering contract before them? Are they going to balk at buying political tickets from the appropriate parties in that municipality or in that government agency? I would say this, that if they buy them before in order to secure the business, I think that's a clear ethical violation. If they pay for them after the fact, I think it's a question of fact on whether there was an implication that they had to buy them before the contract was issued, or whether it was something else. But I also think it's you're bordering on an ethical violation.
Well, and, you know, typically as well, those sorts of documents exist in terms of who made contributions, especially if it's to get somebody reelected. And so this is not handing somebody a $50 bill, at some party or something as some sort of gratuity or thanks. This can be very well documented.
Right. I mean, let's say that the tickets are $1,000 a ticket. I mean, that's not a $50 ticket. I mean, that's substantial.
Well, it is. I think it's a terrible thing to say, but I think one way of looking at it can be is if you do it because you're going with the flow, you can still get nailed. And of course, the fact that, quote, everybody does it, unquote, is not a defense. It's no more a defense than if you're caught speeding and there are 3 other cars that are going the same speed that you're going, but you happen to get pulled over, well, I mean, I think we know you're going to get the ticket. And of course, this is far, far more serious, but it's the same kind of concept as I see it.
Yeah. Kevin, I would say this, just in closing on whistleblowers on this section 19 about political contributions. That would be a classic area where it could come up.
Absolutely. Absolutely. Okay, let's move on, though, to the qualifications and competence and explain what quote-unquote puffing is, Dave.
Well, puffing is a situation where you are overselling yourself in an area that perhaps you don't have or your firm doesn't have the expertise. Does it have any plausible deniability? Well, it's marginal in that regard, Kevin.
Yeah, it can be a concern. I mean, people are entitled to give opinions. I'm one of the most experienced professional engineers in Hamilton County, Indiana, a guy says. Well, it's a little hard to say that. I mean, if the person were a 5-year engineer, that might be tough. But or I have quite a bit of qualification and competence in the designing of blah, blah, blah arrangements or installations. Some of this can be matters of opinion, but you'd never, ever want to represent incorrectly actual facts. I was the designer of the Golden Gate Bridge. Wow. Right. That's kind of silly to even think about, but taking credit when it's really, in fact, a shared situation is a very dangerous thing. And sometimes people, when times get lean, want to overstate what their qualifications and competence are.
Right. I mean, the key sentence that I take out of section 21, Kevin, is that the engineer shall not misrepresent or exaggerate the degree of responsibility in or for the subject matter of a prior assignment. That's a key.
Well, that's right. And Wisconsin, for example, states that very clearly as well. You can't use advertising or publicity which is fraudulent or deceptive. And in Wisconsin, you can't even say you're engaged in a partnership or association with another unless there really is such a partnership or association. Now, I think that that's somewhat implicit in the Indiana rules, but for whatever reason in Wisconsin, they decided to make that an explicit situation. You can't practice under a firm name that misrepresents the identity of those practicing in the firm. So, you'd want to be careful about those sorts of associations. Let's talk about reporting violations. 22, yes, that's certainly obviously an important thing. Here's section 23 that I want to talk about, though, and that is some states say you need only cooperate in the investigation that the board might be making of other PEs. In Indiana, you must report them. You must be the whistleblower if you come to learn of circumstances. I'm looking right now here at the Wisconsin rules, and I'm holding them in my hand, and they are silent on that feature here in Chapter 8 regarding the need to report. Of course, everybody knows that you have to be truthful at all times, and you can't be misleading if you are asked to say what you know. But here, again, I want to stress the need to report.
Yeah, Kevin, can I read the simple sentence out of
Please do.
section 20? If the engineer has knowledge or reason to believe that another person or firm may be in violation of this article on ethics, the engineer shall present such information to the board in writing and shall cooperate with the report or in the board in furnishing such further information as may be required by the board. Well,
so there we have it.
Yeah,
Very broad.
That's pretty and white.
Next week, we're going to talk about whether there's immunity for making the report. And we'll let all of you hang in suspense until next week when we talk about that. Let's move on here to section 24 and 25. Dave, handle the conviction of a crime, because you talked about that earlier.
Yeah, I mean, there's a specific section on convictions of a crime. It goes back to the grounds for discipline that we presented a little bit earlier. Criminal, convictions are going to be problematic. And like I said, Indiana has a pretty broad reading that virtually anything is going to affect your ability to practice as an engineer. I would say with what's on the sheet here, it's failing to pay child support. I think that's where I draw the line. I think the section deals with criminal violations, Kevin, and it does not get into civil problems.
Well, that's right. Let's move on to section 25 about reciprocity. This should be no surprise. If your license is suspended in one state where you're licensed or registered, you certainly can expect it to be affected elsewhere. Wisconsin has a rule that says that if in fact you've suffered disciplinary action in any other states where you're licensed, you must report that to Wisconsin within 48 hours. A very rigid proposition that most people are simply not aware of unless they've heard us talk, but it can be a fast way to get yourself still another charge. So if you don't file your tax return in Illinois and you're licensed in Illinois and Wisconsin, and then you get dinged in Illinois, you better be telling them in Wisconsin really fast if you have any hopes of saving your license there. So as we get close to wrapping up today, let's talk about how to resolve a question. Of course, seeking advice is a great idea, and maybe you talk it over with another PE that you trust on a hypothetical basis, but again, be careful, because if you blurt out something very directly, that person has a duty to report. And it's not that they're ratting on you, it's that you're giving them what some would say is too much information. You're telling them about something that now imposes a duty on them, and you've kind of drawn them into an ethical quagmire of now suddenly they say, Joe, I now need to report you based on what you've told me. One thing that we want to stress, and this is not as big a commercial as it might seem, but if you hire your own lawyer, all of the advice will be confidential. If you're in a large firm and that firm has an in-house lawyer or outside lawyer, you'd want to be very wary about talking to that lawyer, because it could be that there's a conflict of interest between your employer as such and you on the other hand. It's not so obvious. It may be one of those things where it's better to get your own lawyer that only you control, only you receive the allegiance of that lawyer. And again, I'll close by saying, if you think you're too close to the line, you probably are. But you need to get that advice and be ready. Now, we've got just a few minutes left, if at all, and we're going to ask if there's questions. And in the meantime, let me just point out how a week from today we'll be discussing more about Indiana laws, probably talking more about Wisconsin. And then on May 9, still another webinar in this series talking about ethics. And two of my colleagues will be working with me on those. With that, here are the bios so you can read all about us. But let me turn this back to Ariana and ask if there are any questions.
All right, thanks, Kevin. So it looks like we do have a few questions. I'm going to go ahead and read them and give you guys some more time to type in any more if you have them. So I'll start with the first one. I would think that Section 6 would allow Joe to stamp the drawings.
Oh, we don't see how, because if Joe doesn't have that competence, he can't lend his license in that respect. If we change the facts ever so slightly and Joe is like, let's say, a mechanical engineer, and they say to him, can you stamp these drawings? And there's no extraterritorial, there's no Illinois, Indiana business. He still can't do it. Dave?
I agree.
I just don't see how that can happen.
Okay, next one. Regarding undivided loyalty, why is undivided loyalty needed if engineers are expected to be objective?
I like that question.
How much time do we have?
Well, you know, of course, engineers are not supposed to be advocates. They're supposed to be giving advice with professional judgment. But I think the concern is, though, that if you were on the payroll of, let's say, a manufacturer, you were receiving a retainer to represent them and go around and talk about why their products are wonderful, and then simultaneously you're specifying their products and not making it clear to people that you're on retainer. I think the idea is that you aren't, in fact, not being as objective as the appearances would appear or would seem to have them be.
I agree
Dave?
with that. Yeah, I agree with that, Kevin.
It's not just a question of are you, in fact, thinking objectively and carefully, but also what does it look like to someone who doesn't perhaps know all of the facts?
Right.
These are good questions.
Okay, the next one asks if you guys could revisit the loyalty rule with the example of engineer not allowed to compete on a project in which they also act as their municipal engineer. They said that it is my opinion disclosing this relationship to the selection committee would be acceptable.
And I don't disagree with that. Disclosure is a very large part of it. As long as everyone knows, you know, all the facts and is willing to proceed based on that disclosure, I would agree with that. It's just a situation where there's perhaps not disclosure.
That's right, and I'll just repeat my concern about the appearance of a sweetheart deal. But I can appreciate, though, that the municipality says, you know, nobody knows our village better than Sally, who's been our engineer for the last 10 years. Why would we go elsewhere? We like her work.
Right. Right. And it could be that the award was made to the firm and not to Sally, right, Kevin?
Well, that's right. That's right.
Okay, and it looks like the last one. Am I liable if I do not report to PE board for any violation by another PE?
Well, speaking of Indiana, the answer is yes. Dave?
Yeah, I agree. Technically, yes.
Now, again, you know, Dave read literally the words, and there's a little bit of wiggle room, but it actually, I think, doesn't cut in favor of the engineer. What I mean by that is, I think it said may be a violation. In other words, they're not making the engineer be the judge and jury, so to speak, and wait until it's crystal clear. Instead, it's more of what you might loosely call a probable cause standard. If you think it might be, you should be reporting, not waiting until it's beyond a doubt. So yes, I think it's a situation where you can be, shall we say, unfortunately made aware of something, and you weren't the person who caused the problem, shall we say, but now, unfortunately, you have that tar baby effect that you're tainted as well, and now where are you? That's why I was making the comment about talking to fellow engineers about actual facts as opposed to hypotheticals, because you could be drawing them in an unfortunate situation. But let me just say very quickly, in Illinois, for lawyers, it's a very strong rule that if an Illinois lawyer knows about such circumstances, Illinois lawyers have to report. And it's just one of these things where they don't want people who know better to be able to be quiet.
Again, to conclude, Kevin, the rule says if the engineer has knowledge or reason to believe that another person or firm may be in violation. Boy, that's scary.
Well, it is. I mean, our advice is, number one, seek your own counsel if there's a significant enough problem, or just go right ahead and make the disclosure. Disclose facts, do not disclose opinions. And that's something we'll get into next week about the potential for a defamation action. But if you just disclose the facts as opposed to saying, I think that my competitor engineer violated the law when she blah, 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 I'd get rid of all that preamble and just say, I saw Sally take what may have been a bribe, or I saw Sally take money, and I don't know why she did, period. So let me just conclude quickly here by saying that, ethics is something that doesn't give rise to a formula with one simple and only one answer. That just by its very nature, there's some room to go back and forth. That's why it's good to talk about it. It's one of the reasons why, of course, the Indiana legislature decided that having ethics was an important feature of renewing your license. All that said, Dave and I stand ready to consult if and when the need would arise, because we do realize it can be a tough situation. And we appreciate your listening to us and hope that this has been of some value going forward, and hope we can help you again in the future. Dave, any other comments?
No, you kind of covered it all, Kev. Thanks.
Thank you very much.
All right, guys. Thank you, Dave and Kevin. And thanks, everyone, for listening. We will see some of you next week for Ethics Part 2 and the following week for Indiana statutes. Have a good rest of your week, everyone.
Thank you.